All right, today we're jumping into a really tough but super important case, People v. Berry. We're going to tackle a huge legal question. Can the heat of passion that might knock a murder charge down to manslaughter, can that be a slow burn? Something that builds over weeks, not just a single sudden explosion? Let's find out.
So what's really at the heart of this case? Well, it's not about one single snap, one moment of rage. It's about something much more complex. Can 2 straight weeks of intense psychological torment legally count as provocation? That's the million-dollar question. We're going to break down exactly how the court tackled this whole slow burn defense piece by piece.
Okay, first things first, we've got to get into the facts. To really wrap our heads around the court's final decision, we have to understand the specific events that the judges flagged as legally significant. This is the tragic story of what happened.
Now this is absolutely crucial. The court didn't just zero in on one single moment. Nope, they looked at this whole 2-week timeline, starting from the moment Rachel got back from Israel. According to the defendant, Albert, this period was just a nightmare of torment. He testified that Rachel was constantly taunting him about her lover, Yaakov, and then she'd mix that with sexual advances only to reject him. This pattern, this back and forth, is so important because it's what the defense argued built up to that final tragic encounter.
And then we get to the final confrontation, and it starts with this absolutely chilling statement from Rachel. Imagine it. He's in the apartment, and she says, "I suppose you have come here to kill me." According to Albert's testimony, he was completely flustered. He said yes, then no, then back to yes, before finally saying he just wanted to talk. But then she started screaming, and, well, everything spiraled out of control, ending with her death.
Okay, now this is where the defense's whole argument really clicks into place. They bring in an expert, a psychiatrist named Dr. Blender, and he testifies that Rachel's own psychological issues caused her to, unconsciously provoke Berry with this push-pull cycle of arousal and rejection. And here's the bombshell conclusion from the doctor. At the very moment of the killing, Berry was in a state of uncontrollable rage. And what caused it? Not one thing, but this cumulative provocation that had been building for weeks.
All right, so we have the tragic backstory. Now, let's get to the legal heart of the matter. What was the specific question the court had to answer? Murder or manslaughter?
So here it is, the core legal question. After that 20-hour wait in the apartment, was the defendant even entitled to have the jury consider voluntary manslaughter? I mean, could a jury even be given the option of that lesser charge? Or was that 20-hour cooling-off period just a slam dunk for premeditated murder? The trial judge thought so and refused to even mention manslaughter to the jury. And Berry's whole appeal was basically, hey, that was a huge mistake.
So how do you even begin to answer that question? Well, the court had to look at the specific legal rule for heat of passion. Let's break down what the law actually says.
So, voluntary manslaughter is defined as an unlawful killing without malice that happens in a sudden quarrel or heat of passion. Basically, it's for those killings where a person's ability to reason is just completely overwhelmed by intense emotion. It's not a get-out-of-jail-free card, not at all, but it can knock a murder charge down to manslaughter because it gets rid of the malice element. And malice is really just a legal term for that cold, calculated intent to kill.
And this is a super important point. The standard here isn't subjective. It's not about what this particular defendant felt. It's objective. The jury has to ask themselves, would an ordinarily reasonable person have been provoked into a state of passion by these same circumstances? You don't get to have a uniquely short fuse, legally speaking. The law compares you to a reasonable person.
And check this out. This isn't a totally new idea. The court looked back at an older case, People v. Borchers, which established the passion can be stirred up by a series of events over time. So even before Berry, the law already had this idea that provocation doesn't have to be a single lightning strike moment. It can be a slow build.
Okay, so we've got the facts and we've got the rule. Now for the main event, the analysis. How in the world did the court apply that rule to this incredibly messy set of facts?
The prosecution's argument was pretty straightforward. You could almost say it was common sense. Look, the guy waited in the apartment for 20 hours. 20 hours. That's more than enough time for any reasonable person to cool down, right? For reason to take back control. So, from their point of view, this couldn't possibly be a heat of passion killing. It had to be deliberate. It had to be murder.
But, and this is the big but, the court wasn't buying that simple logic. They drew a massive distinction. The traditional view is like a flash fire. You get a sudden provocation and then a cooling period, where the fire goes out. But what the court saw in Barry was more like a slow-burning coal. With a cumulative series of provocations, there might not be a cooling period. The heat just keeps building. The person's reason never really gets a chance to come back online.
And that's where they brought back that precedent, Borchers. The court basically said, this fits perfectly. They saw that 2-week period of taunting as exactly the kind of long-continued provocatory conduct the Borchers case was talking about. So in their view, that 20-hour wait, it wasn't a reset button. It wasn't a cooling-off period. It was just the final simmering stage of this slow burn.
So where does all this leave us? What's the final verdict from the court? And what's the one big takeaway you absolutely need to remember from People v. Barry?
The holding was a big one. Judgment reversed. The murder conviction was thrown out. Now let's be super clear about what this means. It does not mean Barry walked free. It doesn't even mean he was found guilty of the lesser charge. All it means is that the appeals court said the trial judge made a mistake, a big one. By not letting the jury even think about the possibility of manslaughter, the judge committed an error. So the case got sent back for a new trial, where the jury would get that choice.
And that brings us to the key takeaway. If you remember one thing from this case, make it this. Legally adequate provocation, the kind that can reduce murder to manslaughter, doesn't have to be a single sudden event. It can be a slow burn. It can be a cumulative series of events that builds and builds over time. That's the legacy of People v. Barry. So, now that you see how the court analyzed this, think about it. How might this idea of cumulative provocation show up in other areas of the law? It really challenges our neat and tidy ideas about human reason and control, doesn't it? It forces us to ask some really tough questions about where we draw the line between a calculated act and an uncontrollable passion that's been simmering for a long, long time.